Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today I want to talk to you about the subject of the continuous domestic violence law in Texas. In Texas, there was a law that was put together by the Texas legislature in 2009 that created a new offense. It's called continuous family violence. We're going to spend some time talking about that today. And by the way, if you wait around to the end of this video, I will also give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Crime in Texas. Okay, let's jump right into this. What do you need to know about the continuous family violence law in Texas? Well, here's the thing. Let's first talk about domestic violence generally before we lead into that. Generally, especially if it's your first time offense, domestic violence is categorized if it is just offensive contact and no injury or pain. Then it's alleged as a Class C misdemeanor. It's called an assault by contact, and that would be a Class C ticket. You still need to make sure and fight that because that can also go on your record and it can cause you some problems, but that's the first one. Then you go to a Class A misdemeanor. If there's an alleged contact between the parties and it caused the alleged victim pain of any sort, then now you're talking about a Class A misdemeanor of up to a year in county jail and up to a $4,000 fine. But the problem is, what happens when there's alleged ongoing abuse? So if there was an instance of supposed abuse that happened early in the year, let's say it happened in January, and then again in October, there's an allegation of additional abuse that takes place. Well, the Texas legislature looked to try to do something about that. What they found is that they believed that in 2009, they were looking at the statutes and they thought that the law wasn't tough enough on instances where there was a continuous pattern of family violence that was taking place. So they wanted to be able to take what might be on its own individual misdemeanors, and if they happened within a certain period of time, that could now graduate the crime up to a felony offense. That's exactly what they did. So in 2009, they put together what this continuous family violence law that was targeted for habitual domestic violence offenders is the way they labeled it. So under the law, domestic violence offenders who commit repeated misdemeanor-level domestic assaults can now be charged with a third-degree felony. The third-degree felony is a minimum of 2 to 10 years in prison and up to a $10,000 fine. Now, how does this work? Okay, so when we look at continuous family violence laws, here's the way it looks. You have 2 separate misdemeanor assault cases, right? If they take place within the same 12-month period, if they take place within a 12-month period, then now what would be normal, maybe even very kind of innocuous, abstract assault charges, if they take place during a 12-month period, you're now talking about a third-degree felony, something extremely serious. And so multiple Class A misdemeanor assaults committed within a 12-month period, you are now looking at a felony that you must fight. You absolutely cannot have a felony conviction on your record. Number one, you don't want to be facing a possible prison sentence. And number two, it completely ruins your future if you have a felony on your record. Now, here's the thing that's happened. Most of the time, 99% of the time, if you go to trial, the law says that the jury must return a unanimous verdict. That means all 12 jurors on a felony and all 6 jurors on a misdemeanor, they must all unanimously say, yes, they did it. Something strange kind of happened though with this new law. In 2015, the 6th Court of Appeals ruled that in a case where 3 or more assaults allegedly occurred, it's a rare instance, but if there's 3 or more, a jury does not have to agree upon which assaults are proven beyond a reasonable doubt. The jurors just have to agree that at least 2 happened. So if the jurors look at it and say, well, I don't know if that one was proven, but I think this one was, and as long as there's 2 of them that I believe in, then they can still be convicted. Now, that's a rare thing. Usually the jury has to agree beyond a reasonable doubt unanimously. But the law, the 6th Circuit Court of Appeals ruled that is different now. So think of it this way. If you are facing a continuous family violence case, a couple of things you need to do. Number one, If the alleged victim involved does not want to prosecute, it's important that you take certain actions to try to see if your case can be no-billed by a grand jury. It's important that the prosecutor and the grand jury knows the truth behind what actually happened, and that alleged victim has an opportunity to share that information with the grand jury and the prosecutor through an affidavit of non-prosecution, okay? So this is a very serious charge. I've represented a number of folks who have never had anything on their record at all, and there were a few very kind of baseless allegations that took place within 12 months, and now they're looking at a third-degree felony. Now, if you need help with your continuous family violence charge, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I'll be glad to give you a free case analysis, go over in depth with you your specific situation, and we'll be glad to help you if we can, okay? Thanks again for waiting around to the end of this video. If you click the link right down here below, I'll be happy to send you the free ebook, What to Do If You Have Been Charged with a Domestic Violence Crime in Texas. Thanks again. We'll see you on our next video series.